and welcome to this special show on ET Now that we are calling the Data Debate. Now, the draft bill for data protection was finally submitted by Justice Srikrishna to the government on Friday. We got you extensive coverage on Friday evening with voices such as Srikrishna himself as well as Nandan Nilekani, as well as a barrage of experts to dissect the impact of this bill. Now, to read an extensive report and bill, is going to take a lot of time. I'm sure that there are going to be many devil in the details that will emerge in the coming days, but there have already been a few concerns on areas such as data localization, the government's control over processing of data, as well as the RTI Act that have surfaced over the weekend. Over the weekend, we saw time with Justice Srikrishna to really take us through some of these concerns, the thinking behind the committee, and the changes going forward in order to give a better data protection bill for India. Justice Srikrishna joins us on the show this evening. Sir, thank you so much for talking to ET Now. If I just begin with the premise of this data protection framework that you've given, on the face of it, the intent of the report is to unlock the data economy even while you keep the data of citizens secure. So basically ensuring public good even as you protect informational privacy. How difficult a balance is that going to be? And is this balance all the more key for a developing economy such as India, that you cannot be, too stringent like the GDPR, nor can it be too free market like the US? Is that the kind of balance that you've sought to achieve through this report?
Absolutely, you're right. You see, this is not a zero-sum game. Both have to be protected. On the one hand, you have the data that is available, which is really rightfully of the belonging to the citizens. It has to be harnessed for their benefit and for their empowerment. Simultaneously, we can't afford this to leak out to somebody outside India who will monetize it at the cost of our economy. Therefore, it was a very neat balancing effort which has been carried out by the committee.
Right. So, you have a defined consent in detail in the report. But one of the concerns is that consent is only one of the grounds for processing of personal data. The provisions also allow processing of data for reasonable purposes. It has particularly set off concerns in terms of, the rights that the state or the government has to process data. How would you really address this concern? People are saying that, the government seems to have overarching powers when it comes to processing data, and that too personal sensitive data.
See, that is not correct. That's an incorrect understanding of the report and the bill. The whole idea is there may be essential, for example, supposing the state wants to take a survey of whether the plague has been eliminated or malaria has been eliminated. You can't do that without collecting the data. And our state wants to take a survey of how the health scheme has affected the health of so many villages or so many districts. You have got to collect data, and that is absolutely necessary from the point of view of the citizens as well as the state, because citizens have to be protected, state has to protect them, both of them have to interact on the data. Those are the areas where it is possible to do, but we remember there is a catch there. It says as provided by any law. If there is no law, you cannot go around randomly collecting data. Supposing there is some act which says collection of data or statistical data for the purpose of doing this, that and the other, to that extent, absolutely justified. I don't see any difficulty on that. And those are not issues, those are not instances where consent can be obtained from every citizen. Supposing take for example in Mumbai or in Bangalore and Chennai, you want to have a survey of how a particular scheme of the government has impacted the citizens either well or badly. How do you do that? You can't go around asking consent of everybody.
Right. That's a little reassuring to hear, sir. But you've also set out, 4 rights that every data principal has, basically people who own the data. The right to confirmation and access, the right to correction, the right to portability, and the right to be forgotten. Now, there is a question on why you haven't included the right to erasure apart from these 4 rights. What was the thinking behind this?
See, there is a difficulty in that. Now, let's say you have a lot of your financial data in your transactions with the bank. Now, for some reason, you get up and say, I want to withdraw my consent. So, the bank cannot wipe out all your data because under law, they are obliged to keep it under the Income Tax Act for 7 years. If a question arises as to whether a transaction took place, what kind of transaction it was, whether it was legitimate, illegitimate, how do you ascertain it without data on the hand? And the bank can't find itself liable because I did something or you did something. Therefore, to a certain extent, it is necessary. Now, the right to be forgotten. Now, that's a very interesting thing. Right to be forgotten means what? Can you just say, let's say, I'm convicted of theft today, and subsequently, 10 years down the line, can I say, right to be forgotten there, forget it? No, it's part of the record, it is going to be there. Or can you say, right to be forgotten, whether Aurangzeb was a good man or not? That's a part of history. The data that was there is there. Now, historical research requires this to be considered. So, it's not so easy. It's easy for people to get up and say, right to be forgotten. We have to consider an overall view, what happens in a large community, in a large country.
Right. So even on consent, there is one particular provision says that, if the holder of a particular data withdraws consent, then all the legal consequences will be borne by them. Can you explain what this means, and should people be concerned if the onus or the legal consequences are going to be on them once they withdraw consent? In what circumstances is this going to apply?
See, what happens is, let's say I give my data to X for processing, and X in turn hands it down to 20 other sub-processors who all are legitimate people under contracts, back-to-back contract. Now, halfway down the line, I say I am withdrawing the consent. Therefore, what happens to the rest of them? They will say, we don't care. We have a contract in our hand. You will be liable. Therefore, if because of your act somebody is going to be hurt, obviously you have to pay for it. You can't have the luxury of having the cake and eating it. If you cause the difficulty, you must face it. Therefore, before you ask for withdrawal, look at the consequences, look at what the legal liabilities are, then do it in a responsible manner. That's exactly the idea.
Right. So one recurring issue in the last few months is, what happens to a user if he or she has been breached? What sort of notification should be there? Now, your report and your bill also provides a process for notification in the case of breach of personal data by data fiduciaries or the people who are processing the data. But this requirement is limited to notifying the Data Protection Authority, which then decides if they have to notify the person who owns the data or not. Why is the onus on the Data Protection Authority? I mean, why can't there be an automatic way of notifying every person when he or she has been breached?
No, it depends, from the type of breach. If it is something inconsequential, all that you need to do is rectify it. Thereby nobody gets really hurt. Now, whether it's a situation where it is inconsequential or it's consequential, which is likely to lead to significant damage or significant legal liability, somebody has to determine it. Otherwise, every day what we'll be doing is you will be sending out hundreds of notices. Now again, breach is a very elastic term. Breach is unauthorized access by anybody. Therefore, if you really apply the law, then the data fiduciary will be doing nothing else like this only. Therefore, it is better that somebody who is really in the know of things, who can assess the consequences of the damage, if any, then he will say, very well, this is the damage, therefore I am going to notify the data subject also, the data principal also, and also I am going to direct you to take all consequential rectification measures. That is something that is to be left to the regulator.
Welcome back to the special show Data Debate. We are still in conversation with Justice Srikrishna. Sir, in terms of the section on Aadhaar, you have proposed two sets of amendments, one to really bolster privacy measures, and the other, you have said, that they need more powers for enforcement, and you've also said that once this becomes law, the UIDI will also be subject to the data protection law. So does this in a sense make the UIDI more accountable? And is this enough considering the mounting criticism that UIDI has faced in recent months on the way it's administered Aadhaar or the way breaches have happened?
Of course, yes, assuming Supreme Court upholds the law. If the Supreme Court doesn't, the matter ends. If the Supreme Court says it is constitutional, then it is as much accountable under this data protection law like any other data fiduciary. Only thing is, as it stands today, its powers are very limited. It has no enforcement powers. It has no adjudication powers. These have to be given to give it more teeth. It's a question of dental hygiene, I would say.
Do you then, sir, endorse a separation of powers as far as the UIDI is concerned? Because, right now it's a platform that's sort of crafting policies, administering Aadhaar across various states. Do you think there needs to be a regulator on top of the UIDI that will oversee enforcement, oversee policing? Is that the broader idea that you've advocated when you say that there is a need for a regulatory framework as far as the UIDI is concerned?
The UIDA is just, as you rightly said, is just a platform which really comes out with policies. Now it's necessary to have a regulator of the type that we have recommended in the report to ensure that there is proper policing of the thing, there is proper monitoring of the activity of the UIDA, that there is immediate accountability for breach and accountability for not following the provisions of the Aadhaar Act plus the Data Protection Act. All that is necessary. Somebody has to do it, and as the authority today, the UIDA authority today is constituted, none of this is available because probably it was not even thought in those days necessary, and it was one of those pioneering efforts without application of a larger perspective on the matter.
You've also spoken about offline verification of Aadhaar. How is that going to work? Will they also have access to the same CIDR database or the state database? How is this going to work?
Frankly, I don't want to be drawn into a discussion on Aadhaar at this moment because, as I pointed out early, whether this is good, bad or indifferent is yet in the hands of the Supreme Court. Assuming it is upheld, then it is necessary to tighten up the law in order to make it compatible with data protection law. That is all that we have done.
Right. Sir, another sticky point in this bill has been on data localization. This has been flagged off by multiple people. In fact, there are two people in your own committee who put dissent notes on this, and this is also part of the bill. So Rama Vedashri, who's the CEO of NASSCOM's Data Security Council, said the data localization requirement is regressive and against the fundamental tenets of the liberal economy. And even Srikrishna of IM Indore, who was also part of the committee, said that the requirement that every data fiduciary should store one live serving copy of personal data in India is against the basic philosophy of the internet. So, is this a little extreme? Because even Europe's privacy laws do not dictate that a copy of every data should be saved locally. What was the thinking behind this?
Look, there is going to be data fiduciaries of various types. Your street corner grain shop is also a data fiduciary. There going to be a multinational who does all kinds of operations in the digital world is also a data fiduciary. Now, ultimately, the regulator will have to have a threshold below which he will say, I am not going to bother about it. But beyond that, I am going to enforce it in this manner, in the threefold manner that has been considered. So, I don't think that was the dissent note. Was there any real concern for the dissent note to be put on the record? Anyway, that's the view of the industry which has been reflected through Rama and the view of the academician which has been put across. Fair enough. That's for the government to consider in the long run, whether it plays out this way or that.
But should you But will you reconsider this, sir? Because it's being seen as anti-industry, anti-startup by many people, because the cost of compliance is going to go up. Is this something that, will be reconsidered, or, will this come up perhaps in consultations that MeitY or the government has before making this a law?
I am not very in favor of such a thinking at all. See, what has happened is the developed countries were the kids first on the block. So they have got everything stacked in their favor. So now when it comes to a less developed country like India, which has come out with this law, there is going to be criticism saying, hey, don't do this, don't put restrictions on our trade facilities, business facilities. And finally, all trade and business is a matter of international relations. Now if I don't want, you saw, Coca-Cola was also not imported in this country at one time. Did people get up and shout and say, why are we not getting Coca-Cola? Well, today Coca-Cola is also available, Mercedes-Benz is available, Audi car is available. It's a matter of international relations at what level your economy is. This is not something that can be determined a priori. It will pan out as you go ahead. But you need a structure for that. Otherwise, what are you going to pan out on?
Sir, some people also say that the inclusion of criminal offences is a little draconian, that, civil penalties and fines should have sufficed. Do you agree?
Absolutely not. Every statute must have a criminal offence available. Otherwise, people just thumb their nose at it. See what is happening. You see people running away to Antigua and wherever other. If you don't have criminal statutes, you can't even do anything to them. So because there are some criminal statutes where they are answerable, you can move an application for extradition, attachment of property elsewhere. All that is available today. Otherwise, in banking law, what criminal statute was there? There was nothing. It was your PMLA and then various other laws which came subsequently, which of course people shouted and cried themselves hoarse and said, this is draconian, it's going to turn the country into some kind of a servitude. No sir, certainly not. We are still a democracy. Don't forget that. And in a democracy, you are answerable. Now take this data protection law. What is the maximum that will happen? 4%, 5%, whatever is their global turnover.
So the other important aspect is, judicial oversight for intelligence agencies. This is something new we haven't seen before, where you've suggested judicial and parliamentary oversight of intelligent agencies. Again, what's the thinking behind this?
Yes, there is absolutely good reason for that. In fact, at one time, my own thinking was that we should ourselves suggest a judicial oversight. Then I found out that the number, for example, today what is happening, have you any idea? Your data is being tapped without the authority of law. All intelligence agencies are by executive fiat. They are not set up by a statute of parliament. In fact, according to me, it is totally illegal. The reason is, the Supreme Court has time and again said a fundamental right cannot be restricted except by law made by Parliament, and that too the law must stand the test of constitutionality. It should be proportionate to the objectives ought to be achieved. Now, how are you going to discuss this at a priori? I cannot decide all that here. Therefore, there has to be a law. The law must prescribe the procedure. Till then, you will not do anything on the ground of chasing criminals or national interest or security interest, the three mantras that are always given by the executive. It is really eminently in favor of the citizens. Today, Chandra, you have no idea the data that you have, let's say in your own personal life or in your professional life, can be accessed by somebody sitting in Delhi by a mere telephone.
One of the other criticisms that have come out is that, this report has missed a huge opportunity for comprehensive surveillance reform in India. Now, is that because, this was outside the remit of the report, outside the terms of reference, or should there have been more with respect to surveillance reform as far as the Srikrishna committee report is concerned?
No, that is outside our remit. How the surveillance can be done, should not be done, is a job for Parliament to lay down detailed procedure. Now, surveillance may be done in cases where there is terrorist activity, terrorist funding, or there is ordinary criminals or military secrets being taken away. No, I cannot a priori decide what is the procedure to be followed, because procedure may be different in each case. The monitoring has to be different by different level of persons. Some of them have to be judicial oversights. See, even under the criminal procedure code, it is like that. Therefore, it is better that there is a law made by Parliament after which you collect on these three grounds. Till then, you shall not. That is how the law is, the draft reads.
So the other concern is that, this in a sense also weakens the RTI Act because there is a provision for, amendment of RTI where you have said one must look at the harm caused to the holder of that data. Is this a trade-off between privacy and transparency here?
Isn't it? Isn't it? On the one hand, you want data privacy. On the other hand, you want to snoop into everybody's everything. Therefore, there has to be some kind of a line drawn, and that newly suggested section 8A takes a correct balance, the fine balance between the two. In these circumstances, if this is necessary, even the private data can be disclosed. It's not an open issue. It is an issue conditioned upon some consequences. Fair enough. If those consequences are going to happen, if those contingencies do exist, then even my data, which is otherwise private and sacrosanct, can be disclosed. Not to everybody who comes and the point is this, today anybody under the RTI is so widely worded that he can get up and say, I want this information. You ask him, why do you want it? He will say, I am not obliged to tell you that.
So just tell us how all this is going to play out practically, because you will have a data protection authority, you are also going to have sectoral regulators. So, where will jurisdiction begin, where will jurisdiction end, who is going to determine these limits?
Why do you think courts are there in this country? It will play out. Absolutely. Somebody will raise this issue and say you have no jurisdiction. But the moment you say you have no jurisdiction, somebody has to decide it. And who else other than a court? A court of law has to decide it. Now, if one court of law decides it, there is an appeal court and finally Supreme Court. Whatever the Supreme Court says goes. So that is going to be the law of the country. It's happened in every field, whether it is Shabarimala entrance or a Haji, Haji Dargah entrance, or whether there should be triple talaq or there should be LGBTQ rights. Ultimately, it is the Supreme Court which is going to decide the law. Till that time, the law is in a flux. People adjust themselves.
How would you like the community to engage going forward, sir? Should there be more public consultations till it becomes law? How should one go about airing concerns? What's the way forward to ensure that, this becomes an even more better law, even as concerns come in from many quarters?
Look, my own earnest appeal to the community would be, take stock of what is proposed to be the law. Honestly see if it is going to hurt you in any manner, as an individual or as a community, and then put forth your concerns to the government, and I'm sure the government will respond to it. If the government doesn't respond to it, you have your parliamentarians who can take up the issue in parliament, you have journalists who can talk about it, who can write editorials, who can write headlines in the newspaper reports, and of course you are there, the TV media, to debate it day in and day out during 9 o'clock shows.
How have you coped with criticism on how this committee has functioned, sir? A lot of people said they did not make some of the submissions public. How would you respond to these concerns?
Frankly, I don't think any committee can function if you have to keep on saying who said what, to what extent, from what minute to what minute. Nobody keeps minutes of such things at all. The minutes are, first of all, take the standard board meeting of a company. What happens? There is a lot of issues debated which are listed out on the agenda. Then what happens? Then a resolution is passed. The minutes are drawn up. The minutes are thereafter sent to the chairman for his scrutiny. Then after the approval of the chairman, to the persons who are the members of the board. And finally, it's signed and kept on the records of the company. Now, you can't say that I want to know what is going to happen, I want to know what's going to happen, I want to know who said what, and why did he say this.
What next after this, sir? You're also heading an important, panel to look into allegations of impropriety by Chandra Kochar of ICICI Bank. When can we expect an outcome on that?
Chandra, I have decided to take off for 2 months. I'm going abroad, play with my grandchild. And I come back and see, in the meantime, some progress would have been done in that ICICI matter. They'll come back, take stock of it, that's all.
Right. Finally, sir, this is not the first time we've had a framework for privacy. Justice AP Shah Committee 2 recommended principles of privacy. Are you more confident that this will become a law this time around? It will not just remain a bill and a report. Are you seeing more commitment from on this from the political class?
I don't know. That's a question. My grandfather was an astrologer. I didn't study astrology. That's one of my weak points. So I don't know what's going to happen. I have done my duty. Then I step aside and say it's up to you. You, the government, the media persons, and the public at large. My job is done. Yesterday at 4 o'clock.
On that note, thank you so much, sir, for giving us this candid, direct interview. You've taken all the criticisms, the concerns head on. Hopefully, we will see and hear more of you as more details emerge from the report and bill that you've submitted. But on that note, thank you so much for talking to ET Now and, for the instrumental role that you've played in giving India its data protection framework. On that note, that brings us to the end of this special show on ET Now, the Data Debate. Stay tuned to the channel for more news and updates.